Convention doesn't refer specifically to the rights of children. Nevertheless, the Court ensures that where necessary, the Convention is interpreted and applied in a manner which gives greater protection to children. This is because of their particular vulnerability to different forms of abuse and exploitation. As far back as 1978, the Court condemned corporal punishment of children under the prohibition of inhumane and degrading treatment. It ruled in this sense in its judgment in Tyrer against the United Kingdom, in which it recalled that the Convention is a living instrument to be interpreted in the light of current living conditions. As such, it was influenced by developments and commonly accepted standards in the Member States of the Council of Europe, which had come to regard punishment such as birching as unacceptable. Since those early cases, the Court has drawn inspiration from the provisions of the United Nations Convention on the Rights of the Child. It's incorporated the notion that in the decision-making of national authorities and that of the Court itself in a wide variety of cases, the best interests of the concerned child must be the primary consideration. Over the last decades, the European Court of Human Rights has developed its own case law on the specific protection of the rights of the child and has obliged the states party to the Convention to implement the necessary measures to guarantee their fundamental rights, whether in relation to access to court, the right to be involved in proceedings concerning them, family reunification, custody disputes or inheritance, to name but a few.
Protecting children means protecting their right to grow up in a peaceful environment, to be free from any discrimination and to have access to education. The 2010 Grand Chamber judgment Orsic and others versus Croatia concerned the right of Roma children to be free from discrimination and to have access to education. The applicants were Croatian nationals of Roma origin who were, during their schooling, placed in a separate classes composed exclusively of Roma pupils. They complained that they were discriminated against and the access to education was a problem in a concrete case, and they felt the harm that was manifested in emotional, psychological, and also educational way. The government justified the treatment by a poor command of a Croatian language by the applicants. The court found a violation in this case. It pointed out that the classes decisive for determining the placement of Roma pupils in a separate classes was not focused on their language skills, and the program for improving their language skills was not properly monitored. The court found that the treatment of the Roma pupils in a separate classes was not justified, and the court thus found the violation of the provisions that regulate prohibition of discrimination and access to education under the Convention.
La question des discriminations dans les droits successoraux a conduit la Cour à affirmer le principe d'égalité de traitement entre enfants légitimes et enfants naturels. L'arrêt Fabrice contre la France, rendu en 2013 par la Grande Chambre, concernait précisément la différence de traitement entre enfants légitimes et enfants naturels. Le requérant était né de la liaison entre son père et une femme mariée, déjà mère de 2 enfants issus de son union légale. Il était donc considéré comme un enfant naturel au regard de la législation française. Au décès de sa mère, le requérant demanda à bénéficier des mêmes droits successoraux que les enfants légitimes, ce que les cours internes lui ont refusé. La Cour a considéré, dans la continuité des arrêts Marx contre Belgique de 1979 et Mazurek contre la France de 2000, que le droit interne violait la Convention. Elle a estimé en effet que la différence de traitement entre les droits successoraux du requérant et ceux de son demi-frère et de sa demi-sœur était discriminatoire et n'avait pas de justification objective et raisonnable.
The duty of the authorities to protect minor children is particularly important when children are placed in state care and orphanages or are educated in schools run and financed by the state. The case O'Keefe versus Ireland from 2014 concerned the Irish state's responsibility for the sexual abuse of a 9-year-old child in the 1970s by a lay teacher. Irish national schools were then run and managed by the Catholic Church, but they were financed by the state. The Grand Chamber found a violation of the Article 3 of the Convention, the state having failed to protect the applicant from the sexual abuse to which he has been subjected to in the national school. It has also failed providing an effective remedy allowing the applicant to have the abuse recognized by the national courts. The court emphasized that the protection of children from ill treatment is an inherent obligation of the state, especially in primary education. It considered that the state should have been aware of the level of sexual crimes against minors, given the level of prosecution of such crimes at the relevant time. The state has entrusted primary education to non-public institutions, but the inspections and complaints mechanisms, which existed in the 1970s, has proved ineffective.
Over 30 years since the conclusion of the United Nations Convention on the Rights of the Child, recognition of the need to protect children in our societies is widely shared. While this convention is one of the most widely and rapidly ratified international treaties, the court continues to receive many different types of cases, which demonstrate that children's rights are not yet fully effective or respected. It's unacceptable in the 21st century that children still face abuse or discrimination, that some children cannot access education in normal conditions, or that they're deprived of the possibility of peaceful social and emotional development.